So, a very good morning to all of you. So, how are things? Hmm? Had breakfast? What did you have in breakfast? Hmm? Paratha. Very good. It stabilizes a person for at least 2 to 3 hours. No? If you are hungry, then sometimes it may jeopardize your study time and the class too. And if you are hungry in class, in between, then what is the remedy and solution? उसमें स्टोर होता है. When you tear it, open it, wrapper makes sound, and when you eat it, it is also having some sound. So what? Hmm? So there's some liquid epi straw inside, and the fellow will not be using it because for the obvious reason. But biscuit you have to share forcefully, compulsively, and you cannot ask your fellow bring your things tomorrow. I'll share. It's a choice. Yes or no? So yesterday we were talking about the public interest litigation, judicial activism. Judicial activism we discussed, and what did we discuss in judicial activism? That it is the exercise done by the court by taking up the executive powers because of not responsiveness, because of not responsive executive timely, right? But judicial activism is good in the shorter run, but in the longer run it will be resulting into diluting the concept of separation of power between executive and judiciary, and it has to be used sparingly. As the last resort. Sparingly means rarely. Resort means option. Okay. And in the executive judiciary meet every year, especially on the Constitution Day 2015 onward, which is celebrated that way, 26 November. So they have uh, pointed out, the executive, that we are having unnecessary problem by more and more judicial activism which is not called for, and of course it may be labeled as judicial adventurism, and the judiciary is having many more cases that it it has to address, like pending of the cases which are lakhs in number when we look at the subordinate judiciary and the high court. Subordinate judiciary means the district court, the metropolitan court. And because of this fact, we gave birth to the other judicial mechanism which are working on the reconciliation method. For example, Lok Adalat. For example, fast track courts. The fast track courts were basically set up because of the recommendations given by 11th Finance Commission, and for this you have to give the money also. Fast track court, building required, number of judges required, a kind of local clerical assistance is required. Yes or no? 500 crore rupees were sanctioned for this purpose. Now the fast track courts is also having its own story, that in many of these states like Karnataka, Manipur, they are having good success ratio, but in other states these are lying redundant, idle, not working, on the verge of collapse, right? But again, like in Chhattisgarh, the fast track court in October has been set up in jail to dispose of the jail inmates case. Inmates means the prisoners, right? So this is somehow is there. So Supreme Court has to look at some of the vital questions, the vital cases also, but not the judicial activism. But it is also required that the government is very able, sarcastically. So judiciary has to look after the able government, so-called able government, in their own eyes, but not in the eyes of the country. Especially when the coalition form of government is there, when survival of the government is thought more rather than the survival of the nation, right? So in that sense, the judicial activism has to be written in the main examination 2023. No? So we can write one line about it. Judicial activism. हेडिंग तो आपने कल डाल लिया था ना, yesterday you put the heading judicial activism. It can be defined as the active judicial role by taking up the executive powers because of not responsive administration. Judiciary may go out of its traditional role and discharge the executive functions to maintain rule of law. It has helped in reinforcing the strength of democracy and reaffirm the public faith in rule of law. Full stop. Judicial activism, in a sense, has been forced upon judicial activism has been forced upon the judiciary by an insensitive and unresponsive administration administration disregard that disregard the interest of people. People. Full stop. Judicial activism connotes 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 and connotes the active role of the court in the legislative business too. In the legislative business too, and that is why it emanates. Emanates means comes out or evaporate out of it. It emanates from the power of judicial review. Power of judicial review, and it is exercised by Supreme Court and High Court both. High Court both. Full stop. PIL is a major facilitator for judicial activism. Is a major facilitator of judicial activism, and it is called as backbone of it. Called as backbone of it. Next paragraph or next point. However, judicial activism may be a welcome measure in a short run but in the longer and larger scenario it will dilute the concept of separation of power and it destroys the checks and balance mechanism. Checks and balance mechanism. It will result in domination of one co-equal organ dominating one co-equal organ on the other that too without adequate accountability. That TOO2 without adequate accountability and expertise. Full stop. A Supreme Court bench in 2007 observed that court in the name of activism Doing executive and legislative work is not good. Is not good. And judges are not expected to run the country. And judges are not expected to run the country. The country. Full stop. Moreover, judiciary is not a representative popular body. Judiciary is not a representative popular body, nor it formulates the policies, nor it formulate the policies, comma, nor it communicate with people directly, comma, nor it has expertise and knowledge, expertise, comma, knowledge and training to deal with field executive scenario, to deal with field executive scenario. Full stop. The court therefore, the court, comma, therefore must employ self restraint, restraint. Restraint means self discipline type of thing. Restraint, comma, evolve a code of conduct, for judges while practicing judicial activism, which should be used sparingly, which should be used sparingly as last resort. Last resort, comma, otherwise it will be labeled as judicial adventurism. It will be labeled as judicial adventurism. ओके, तो क्वेश्चन आ जाएगा तो ऐसा तो लिख दोगे हैं? यदि ऐसा लिख देते हो तो 60% मार्क आ जाएगा, मतलब उस क्वेश्चन में, with some of the current examples indirectly. जैसे जुडिशियल एक्टिविज्म करंट एग्जाम्पल 13 नहीं, अभी 1920. एंड फायर क्रैकर को बैन करना तो अच्छी बात है. Say for example monkey manners, say for example Delhi parking episode. In parking episode you see that what is the problem here, right? So they told that every wrongly parked car will be bent It will not be further allowed to fly on the road. चालान होगा ठीक है but नहीं. Then Corona time, all the Corona warriors, all the Corona warriors will be out for duties. भाई ये कौन सी बात हुई? Hospital administration will run the way it wants, and then the bedded hospital, for example, in the five-star hotels and all, the bedded hospitals were allowed. So there, the poor person can also be admitted. Why it has been done, and if a hotel is allowing itself to be a corona hospital, then of course the people of affluent class, they want and they will pay. So it in that sense balancing both the things together, but then it is coming in between. Now who will examine that the needy person is to be admitted in that hospital or not? What great work that needy person has done. Means I'm not discriminating. Jallikattu means the bullfighting, taming of the, taming the bull. Taming means stopping the bull, called as Jallikattu in a vernacular sense. So it was also a part of animal cruelty. Then stray dog episode, it's going on, right? So what should be done for the stray dogs? Hmm? Hmm. Training for the owners. It is required, and basically municipality is to look after the stray dogs, that oh, the dog which is not good for the people, the bypassers, that will be captured. Now how the municipality will be identifying? You're getting my point. Then one person uh, started beating the dog to death, and means the dog died, and it was registered, the case was registered. Now the person is saying, sir, if the dog is biting me, then it is fine. But if it is biting a child, 1 year old baby or 2 year old baby, then what should be done? Anyone out of the emotional fury will, will do the same, including anyone, including the judge also. Because one has to save. Defense, it is. It is as if the behavior of the person was there in court. Sir, I should allow me to be bitten by the dog. कि आजा बेटा आजा काट ले. This was the kind of thing in front of judge. So I mean, it is a mockery, and the people who are into the activism to save the animal, they are that blindfold that they cannot see other things other than the animal. PETA, you understand? PETA is a body. So judicial activism, that police person will also be will also be kind of vigilante, vigilantism. So vigilante in observing the stray dogs, then they can report the matter. Then the cow vigilantism, if I can recall. So prevention of supreme scheduled caste and scheduled tribes atrocities act 1989. So when Modi government uh, efforted to save the cow, so Modi Bhakt, nahi cow Bhakt, sorry, came out that गाय हमारी माता है, हमको whatever, cow is our mother, right? And we will save it. So if I am taking cow to my house, purchasing a cow, and I'm taking it my house for milking purpose, and if one enemy of mine has noticed it, then in the name of party work or cow vigilantism, he has started beating the people. Now, after the inquiry or people come to know about reality, that is a different case altogether. But once episode has taken place, means taken place for no point of return. Injury happened, no point of return. After that, sorry, that's it. So, Prevention of Atrocities of SC/ST Act 1989 is there to save the interest of the scheduled caste and scheduled tribes. How they are saving, how the interest is saved of this class? Say for example, I am of this community, and if you have passed one skewed remark, right, like your community is this blah blah whatever, SMS, WhatsApp, that can be treated as an evidence. An FIR can be registered against you. So one Dalit leader contesting election in UP, Bihar, and if you have passed comment for his or her leader, Dalit leader, then of FIR will be booked. You can be representative to save the dignity, so-called dignity of that Dalit leader, like what happened in UP. In UP, one of the person is quite popular in that sense, but otherwise sentiments are to be, contained. But SC/ST community was taken differently by the court. What does it mean? It means that the court held in a judgment that the evidence is required before you arrest a person who has dented the dignity of one SC/ST person. And Prevention of Atrocities Act for SC/ST says that evidence is not required. So where we should go? If one person is from SC/ST community and one want to settle the score, right, then one is expected to use, one may use this act, otherwise also or not, and that is why it was done. But the vote bank politics, the parliament reinstated the very spirit of the law that was otherwise scrapped by the judiciary, but then judiciary again was facing the case, and in that case the judiciary upheld the spirit in the original format. So in between it happened, but judiciary finally is saying then okay, whatever the law is fine. You have understood what did I say? So these are the things. Review. Hmm? No, NJAC. eh, No, it went for 3-4 months. The case, NJAC case, the attorney versus the defense side. So NJAC case, there was a long debate, long debate that why a judge should be appointed when the retirement period is left less than 2 years or around that. Why not all 6 years or at least 5 years must be allowed, right, for CGI to be in office? If one is appointed at the age of 60, at least one will be there for 5 years, right? But NJAC was scrapped. That was good. Earlier attempts were made, right, to contain the judges in their own domain. 1968, why that year Judges Inquiry Act? It is coinciding with that period wherein the democracy was all time low till that time. Why 1968? After the demise of Nehruji, the huh? Yeah. So first division split was there in 1969. Why first division was there in 1969? From the same political party, two presidential candidates were there contesting presidential election. Gyani Jail Singh and V.V. Giri. Sorry, sorry. Neelam Sanjeeva Reddy and Shri V.V. Giri. Neelam Sanjeeva Reddy was from syndicate side. Syndicate means South Indian side Congress, and indicate means North India side Congress. Congress is a big party. But the maturity of a person is counted always. Decency of a person is counted always. But Indira Gandhi ji was little assertive, and of in her age, not having that maturity and having decision at her own, right? Some of the small decisions were giving good signal that she cannot take over this big role, and that is why Lal Bahadur Shastri ji were he was brought as a puppet PM. So whenever the government is weak, the judiciary takes assertive role, and that is why you can recall what happened in 1964 and 1965, the Golaknath case. What happened in the Golaknath case? In Golaknath case, last 15 years spirit was reversed. How? Last 15 years reversed? In Shankari Prasad case, 1951, judiciary held that parliament can amend the constitution, any part of the constitution. But Golaknath case, one day good judiciary is saying that no, 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 constitution is a fixed document. Parliament cannot amend it. It means what? One organ of the democracy is dominating over the other, which was not really good for separation of powers. Anyway, so this is the spate goes on. Now, mm, especially the Pregnancy Act Section 499, the uh, decriminalizing the third gender LGBT things, right? And the property going to the daughter also is all part of judicial activism. You're getting my point or not? The daughters, whether married or unmarried, have equal right of property. You know, co-partionates. You guys are co-partionate or not? Co-partionate is a word. Co-partition. You don't have co-partition in your house with your siblings. So co-partionate. So as a daughter, will you be asserting your property rights or not? Can't say. Can't say. But judiciary has allowed you. Okay. So boys are thinking that what will happen next. Small property that to be divided. But anyway, now the next issue is the Article 2 129. Article 129, contempt of court issue. So what did I tell you about contempt of court? Supreme Court and High Court both are court of record. In two sense, it can be seen that whatever the rulings is to be used by the other courts while solving the future similar case. Then second thing, that if one is not respecting the court or tend to scandalize the interest of the judiciary, scandal, scam, scandalize the interest of the judiciary by defaming it. कोर्ट में जज साहब को कुछ नहीं आता वगैरह वगैरह. So it will be contempt. Constitution is silent about contempt. It is not defining that what this contempt is all about. And that is why Parliament brought 1971 Act to define the contempt. In 1971 Act, Section 2B and 2C defines the contempt as civil contempt and criminal contempt. Now this civil contempt, if you look at, means if the order passed by the court, you are not obeying it, right? The you are means you are the government, you are an individual, you are an organization, whatever, and you are a lower court. You are a lower court too. And if it is seen in form of the lower court, then you may recall the writ of prohibition. What prohibition writ is saying? Prohibition means it being a lower court, if you are hearing a case and if the higher court is saying that it is not within your domain, not within your territory, not within your jurisdiction to hear it, you are going out of it in excess of your jurisdiction, then please transfer this case to us. Then it is also an order and you keep on hearing it, then it is civil contempt. The criminal contempt means you are printing, you are speaking, or you are acting in a manner which is lowering the respect, the image of the judiciary, then they will take it. And even if you are speaking about a person who is a judge, then also it is a criminal contempt, because it is to protect the seat of the judge, not the person. But the person is sitting on the seat, then it is one and the same thing. And that is what happened in case of Prashant Bhushan ji recently during Corona time. Which bike it was? Harley Davidson. Okay. So without helmet. So picture was there in one of the national daily, and on the basis of it, it was filed, and finally ₹1 was fined. It was a kind of a stunt, maybe, because all people came to know, widely reported. So many more cases will be coming to a lawyer that one is having guts to go against the interest of CJI. This is what contempt of court is. But don't you think that contempt of court is not a fair mechanism? And if so, then why? Now, being a media, you cannot speak against the judgment given by the court. And democracy, Article 19(1)(a) talks about freedom of speech and expression. You can freely criticize the government decision. right? But you cannot criticize honestly the lacunas, the silent things, the gap in the judicial decisions. This is number one thing. And because judiciary cannot be criticized by the media, this contempt of court mechanism is treated as sword of Damocles. No, shaitan ki talwar. You know Damocles? No? Arbi? Demo? Demogods. In Harry Potter, what was the name of that demogod? Watermoors. Okay. Sword of Damocles. Sword of Damocles. It's there is a story I'm forgetting. I read it in my childhood. So there is an expression. It has to be used while writing the answer. So sword of Damocles is hanging on your neck or here. And if you are moving here and there, it will be dropping on your head. Right? Two pieces. So on media, this sword of Damocles is hanging on its neck or on its head. They cannot go for the honest criticism also. Then second thing is that isn't against principle of natural justice, that I will be judge of my own case. So you will write the answer and you will check the copy of yours. So 100 नहीं 110 out of 100 यही करोगे 100 में से एक तो 10 नंबर 110 out of 100 everyone will give like that. So principle of natural justice has been compromised because of contempt of court, that I will be judge of my own case. It is objecting to. You are getting my point or not? And the contempt of court has been amended in 2004. In 2004, that the judiciary can revise its mistake at its own, and the court of revision, the High Court and Supreme Court both, has to work for all the aberrations that they have done. Aberrations means the mistakes. Article 129. Right? You're getting my point? So the question may not be there in the conventional polity GS paper 2, but it will be there in the governance. How the question may be there? That a new form of judicial governance is coming up. Judicial governance is coming up. So judicial activism is one part, but then contempt of court misuse. Judicial governance is coming up, but it is not good when the judges are judging their own acts. Explain. Okay. So governance is a big issue, and if the courts have been mentioned in this directly or indirectly, then definitely you will have to mention it. So we can take one line about Article 129, and Article 129 goes for Article 215 also. Article 215. Article 215 for the states. Both High Court and Supreme Court are code of records. Okay, please write. Article 129 declares Supreme Court as court of record. That is judicial decisions and proceedings, judicial decisions and proceedings, proceedings, proceedings are admissible as evidence as evidence in all courts to solve future similar cases future similar cases future similar cases full stop. If court apostrophe s court's rulings are not obeyed, then it is called as contempt. Contempt full stop. Though it has not been defined in the constitution, but it has been defined in Contempt of Court Act 1971, which classify contempt into two categories. That is civil and criminal contempt. Civil and criminal contempt. Full stop. If a person willfully willfully breaches breaches an undertaking given by him to court or willfully disobey the court's direction or order, then it is civil contempt. Full stop. Criminal contempt means publication of any material or commission of any act. Commission means doing, committing. From the word committing, the commission of any act that scandalizes or tend to scandalize, tend to scandalize or lower the court's authority or tend tend word is from intend tends to interfere with due course of judicial proceedings in any manner. Okay. And right below this, Supreme Court has held that Supreme Court has held that the 1971 Act is meant to protect MEND is meant to protect the seat of a justice seat of a justice, but not the judge, but not the judge. So under section 16 of the SAD Act, under section 16 of the SAD Act, comma, even a judge can be held responsible for contempt of his own court. Contempt of his own court. Full stop. Right below this, however, the contempt jurisdiction is criticized because of number one, the alleged 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 oversensitivity. Alleged means आरोप लगाने वाली बात. Alleged oversensitivity of the court to even healthy and innocent criticism of media, innocent criticism by media. The number two, the judges judging their own acts, the judges judging their own act runs against the principle of natural justice that no man shall be judge of its own case. And right below this, under 1971 Act, even a truth cannot be used as defense by the criticizer or condemner or a condemner, right? CONDEMNER. Full stop. Further, the contempt jurisdiction has become debatable the way it was applied in the court. Full stop. Accordingly, Accordingly, an amendment was done to 1971 Act in 2004. 2004, which states that, comma, no court shall impose a punishment for contempt it is satisfied that unless it is satisfied that the contempt substantially substantially means very much, substantially interfere the judicial proceedings, right? The parliamentary committee on law and justice the parliamentary committee on law and justice also the hope expressed the hope that the related judge against whom the alleged contempt has been frame will recuse 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 means will not sit. Recusal means withdrawing, or will not sit in the judgment as per principle of natural justice, right? रिक्यूजल नहीं किया था तो हाँ, many of the cases recently in 2019, the recusal was not done. That recusal mechanism also came under attack. You cannot be judge of your own case and you need to recuse. Even within 5 months, you are appointed as member of the house. It is a violation of something called as cooling off period. Earlier it used to be 2 years. Now it has been reduced to 1 year. But there is a law, there is a catch, that if the permission has been granted, you may join. Maybe you have lots of burden on you. Permission respective ministry, especially Ministry of Personnel. बिल्कुल कर सकते हैं. नहीं, सॉरी का क्या चल रहा था? We can criticize the president. Huh? Backing in the sense, Article 19(1)(a) is there. Article 19(1)(a) stops you from criticizing the court rulings. That's it. Stops you means it has not been given those wings. But president being union executive, part of parliament, has been criticized, can be criticized. Can be criticized. There are many countries. Even in United States, judiciary can be criticized because there is complete separation of power. They can criticize. Means the government. किस चीज में? डिबेट्स में? हम्म हम्म हाँ, डिसेंट में तो होता है जजमेंट. I tell you, you can criticize as an individual, and you can be reported in the media that this person was criticizing the judgment. If the judge or the judiciary is not taking action against you, it is their take. Number one. Number two, if a media has been reported that they have done it or they have conducted the show and the petition has been filed, then the license may be cancelled. Then number three, if any minister or the government is criticizing the decision given by the court, then it will be a contempt, because who is gonna to uh, pay attention to what you have said, being a mango person or aam admi, common man? You understand this? So if the government has said this, the opposition will definitely be grilling it, and the media is running it. So if you are just discussing the judgment given by the the court, then there are pros and cons, and there is a discussion and debate going on. And if it has not been reported, the judiciary has not taken suo motu cognizance, nothing will take place. But yes, the judge can take suo motu cognizance that my decision has been criticized by this media, and his its license should be cancelled. It can be done. पावर वो करती है, उसके लिए रिव्यू होता है, द जुडिशियल रिव्यू, एंड द डिस्कशन इज देयर. Yes, the legislature can criticize under the roof of the parliament, but the government cannot rule. Government cannot criticize it, and that is why there is a maxim that within the roof, under the roof of the parliament, if you have murdered someone, it will be excused. Right? Means not in that sense. Means what happens actually, that while criticizing the things no one is hearing under the noise and din, so they have started, using the furniture to throw it on each other, right? So nowadays what is happening, that the furniture is of good wood, fixed one, that they cannot do anything. So it was done in the Kerala assembly, that they were throwing chairs on each other. Some of the people were brutally injured in that episode. Even in the parliament here in Lok Sabha, Meera Kumar used to be the speaker. The paperweights, you understand paperweight? If I throw and if it is hitting your head here, you may be a departed soul. Okay, so the ink was thrown. The mic of the speaker was broken. Right? Thank God the idea was not there. The mic of the speaker, the current of it. Okay, so it can be excused. Only one thing may take place. The marshal may be called in to lift you up. They are sufficiently muscled in that sense, having muscular strength, with respect, they can take you out. That's what is the possible thing, right? And एक एपिसोड हुआ है वो मुझे याद नहीं है कहीं मैंने बिकॉज यू नो इन यूपीएससी दीज आर नॉट थिंग्स विच आर mentioned but in the curiosity to know inquisitiveness in childhood these stories there is a case wherein the person was on the verge of death because of something happened in the parliament, but it's of no use for exam. Yes, the constitution is silent about it, but it is written that any act in the under the legislative house is excusable. You can openly criticize the judge, means as a legislature, not as an executive minister. Government is an executive, but legislature is lawmaking body. Legislature means maximum 545 people, 45, 45, 43, 543 people in Lok Sabha, right, as of now. But government maximum 15% means 83 or 84 ministers along with prime minister. This is what the government is. Okay. Now, after this, we will be talking about Article 130. Yesterday, I told you about the constitutional benches. The regional benches are also a concept which was there recently in news in the month of October, that the Supreme Court should set up the regional benches at least in the metropolitan cities, in West Bengal, in Madras, and in Maharashtra, Mumbai. Many cases are there. And this is not a new recommendation or new need that has been asserted, but the Supreme Court has not set it up. Article 130 says that the President may allow the Supreme Court to sit in Delhi as well as the reasonable part of the nation, India. But Supreme Court has not done it. Yesterday I told you why. Not the convincing reason it is giving that it may come under the political influence. But why it is needed? Number one thing, it will become a role model or benchmark for the subordinate and state level judiciary, that the Supreme Court is working there. Then second thing is that the person who is coming, living here, lodging and boarding, traveling time, the money is spent and date after dates. Okay. So which is stopping a person to practice or to enjoy his or her Article 19(1)(f). Oh, EFG. Article 19(1)(g), right? Especially Article 19(1)(g) is talking about what? Freedom of work. Freedom of work and profession. So if you are not working, how will you be winning bread and butter? So Article 21 is also restricted in its meaning. So you should not come to the capital, but the capital court should reach your doorstep, like the way Lok Adalat is working. But how to write an answer for Article 130? Yes or no? तो क्या लिखना पड़ेगा उसमें? उसके लिए हमें एक लाइन लिखनी पड़ेगी छोटी सी, because it is expression full thing and the facts are not there in it. Please write. Article 130 of Indian Constitution provides that Supreme Court shall sit in Delhi, shall sit in Delhi and such other places as CJI may decide with the approval of President. CJI may decide with the approval of President. The Law Commission of India, in his report, in his report, in its report, sorry, has pointed out that litigants, litigants, litigants means the applicant in the legal domain. Litigants may have to travel long distance to have access to the Supreme Court. Full stop. In most cases, litigant feels the need to retain the same lawyer who has handled the case at high court level. High court level, right? Also, appointing a new lawyer in Supreme Court, is very costly affair. Lawyer appointing a new lawyer and in Supreme Court is a very costly affair. We'll stop further. After amendment to CPC, CPC means Civil Procedure Code. 1908 in year 2000, comma, the cases decided by High Court single judge bench cannot be taken up by High Court 2 or 3 judges bench, 3 judges division bench, and the case can only be taken up before Supreme Court. Supreme Court that force litigant that force litigants to travel to Delhi, litigants to travel to Delhi. Full stop. The Parliamentary Standing Committee has also recommended for setting up of regional benches for setting up of Supreme Court regional benches for common man's benefit. For common men's benefit. Full stop. The Bar Council of India, BCI, Bar Council of India has also reiterated the same. Has also reiterated the same. REITERATED. Reiterated means repeated the same or extended the same recommendation. The same. But Supreme Court has turned down such request at least 4 times so far. So far, Supreme Court says that setting up of RBs, regional benches, RBs will affect unitary character and its integrity which seems too formal and theoretical too formal too formal and theoretical. Full stop. The fear means apprehension. The fear of the court may be related to the political influence of the region that can be casted on RBs full stop. But in such cases political parties and the public sentiments are prevailing prevailing for the high court related case or the high court related cases and in Delhi too full stop. So the RBs must be set up at least at least in the metro cities of India to begin with. To begin with, and and High Court must be allowed must be allowed to have its RBs too. To have its RBs too. RBs means regional benches. Right? Understood. Now, in 2019, what happened that the the judicial appointments were delayed, and judicial appointment we have seen under Article 124. What is the time limit that judiciary has imposed on as the cutoff date or cutoff time that the judicial appointment must be taken up for the recommended name? टाइम लिमिट नहीं है तो फिर क्या करें? अब मान लो that one high court judge is to be appointed. Finally it will be done by the president, and before the president there comes collegium system. Yes or no? There comes collegium system, but before that what happens? In collegium you have CJI plus 4 judges coming from Supreme Court and High Court. What happens? The High Court Chief Justice communicate things to the governor. Whom? The governor. Governor consult the chief minister. Then after that it is communicated to the president. Then president communicate it to the prime minister. Then prime minister communicate it to the ministry of law ministry. Right? Then they communicate with whom? CJI. Right? Or what they do, that they revert back to PM to president, then to governor, and then to CJ. Then they may have the direct dialogue. And when the name has been decided by both of them together as part of this collegium system, again this route is followed. And this exercise must be completed in 6 months time. Now the catch is this, that in how many months it should be taken up. The court is of the view prescriptively that within 6 months the name should be taken up for the appointment. It is not a foundation, constitutionally speaking, on the government or the president to appoint him compulsorily, until unless it has been amended or it has been passed by the court as an order that it has to be done. It was the latest episode of 2019, and the data was showing that around 38% vacancies are there in the High Court and the Supreme Court for the judges. Then if we talk about the judiciary and RTI, that is CGI under the RTI. No. So what asset CGI is having is not should not be known. So what is the discretion of CIC, Chief Information Commissioner? What is the discretion of CIC? If they ask something from the court and court deny, and court cannot deny directly. In the court administration, there is something called as Public Information Officer, PIO. He will deny that I cannot give it under RTI Act Section 8(1)(j). There can directly be a question for Section 8(1)(j) of RTI, that what this section is all about in mains exam. So this is a kind of defense shield for most of the organizations of RTI, that we cannot divulge the information on this pretext or the other. This pretext or the other, because it is a confidential information. There are 4 types of document in the administration. What are those? Top secret, secret, confidential, and classified. Classified can be shown to the people. Classified means, again, these are classified, not open. Then there comes confidential documents. Confidential documents can be shown to the person who is needing it, not to the media. Secret and top secret documents cannot be divulged to the court also. Now, as a judge, how much property you are having can be asked or not. So it is under the RTI or not? It is under the RTI, that the judge was denying it, and then the same court allowed that, yes. Then your siblings are having the property. Is it under the RTI or not? It is. Your spouse, means the judge's one, if it is so, then it is also under the RTI. You will be taking the money, or you will be creating the assets, maybe not on your name, but on your relative's name. In the British time, what used to be there? The servants, the civil lines and lines area of Delhi, the millionaires and billionaires people, they were the servant of the British time area. They left it and they named the property in the name of, they registered the property in the name of the servants, and they became the billionaires and billionaires. Civil lines area, wherein Arvind Kejriwal ji also living. The ridge of Delhi University, North Campus. Okay, so this is something which is very, very important. Then what is the meaning of per in curiam? This is actually just current affairs. Per in curiam. Per in curiam simply means the court has decided something wrongly, and it has to be taken up as part of court's mistake. What is to be done then? The court may do it for 2 things, means the court may commit mistakes on 2 pretexts. First, the process has not been followed, legal process. or there may be really an aberration overlooking some of the vital fact of the case. Yes or no? So in India, the practice like what happens in case of US, that all the judges sit in every bench, should be practiced or not? And apart from the judges, there is a jury as a body. You might have seen in the reality shows nowadays that apart from 3 judges, the 30 other judges are sitting. In the reality shows, Sare Gama Pa, Dance India Dance, the jury is meant or membered by the retired people or the eminent jurist. So their opinion cannot be subsided that easily. If all are saying thumpingly yes and you say no, will it not be a matter of study? That all should fall in one line or at least more than 50% from both the side. So if there is a tie in the even numbered bench in case of US, then the jury opinion will be helping it. Right or wrong? So if we talk about the comparison of the constitution and the judiciary, then some of the new practices we need to incorporate or not, or at least we can mention in the answer to get to fetch more marks. हमें क्या करना है? Judge कुछ भी करे. Whatsoever is done in the judiciary, whatsoever done in the government, we need to get more good marks. That is what is our dharma nowadays. Right? So these two small things we may write. Please write about section 81J. Write in it. In Subhash Agrawal RTI issue, Subhash S H U B H A S H, Subhash Agrawal RTI issue, Supreme Court recently declared the office of CJI as public authority under RTI. The relationship between RTI and judiciary is very challenging as RTI makes CIC, Chief Information of Commissioner, CIC, as final authority but CIC decisions are challenged in Supreme Court and High Court. Wherein generally the court ruling is opposite to CIC order. Full stop. Section 8 clause 1 subclause J of RTI Act is invoked by government official for not disclosing information and because of this section because is invoked by the government official for not disclosing information, and because of this section, comma, PIO steer STER steer themselves safe in court. Steer from the word steering of the vehicle, right? Steer themselves safe in court. Full stop. Also right to privacy issue was examined. Right to privacy issue was examined in 2009. In 2009, when a copy of complete correspondence when a copy of complete correspondence exchanged between CGI exchanged between CGI and government was asked with regard to the appointment of the judges. Appointment of the judges. Currently, not only the office of CGI, but the personal life of the judges is under the purview of RTI. For example, the property held by them and their relatives. For example, the properties held by them and their relatives. You may check it in the Google if you want to know the property held by the Honorable CJI. Then put the heading per incurium. PERINCURIAM. Incuria is a Latin word. Incuria is a Latin word, means carelessness. Is a Latin word, means carelessness. Full stop. When a judgment is declared PI, declared as PI means per incurium, comma, it means that the case was wrongly decided. The case was wrongly decided. It means the case was wrongly decided. We'll stop. In US, all judges of Supreme Court sit together. All judges of Supreme Court sit together for hearing every case. But in India, we have the concept of benches. Membered by limited number of judges. Membered by limited number of judges. right? In the land acquisition, issue 2018, actually इसमें in this case what has happened in Indore, there was one property where that the owner was not willing to give or to sell forcefully to the state government. Government had to take it for developing it as a national or a state level project. Maybe the dam, not the dam, the road and the bridge. So then what should have been done? So it was decided that okay, the money from the state government which is to be given to the party and the party is not taking it, you please deposit it to the treasury. Earlier what was the issue? That you please deposit it to the treasury of the court, that if tomorrow court is deciding in favor of the owner, then the money is to be returned back, or the more money is required whatsoever, then treasury of the court, it is easier for the court to decide. But the treasury of the government means another episode. Bankrupt, money is not there, wait for another financial year, affidavit put. So delaying in the civil case is a normal norm. So please write, in the land acquisition case 2018, three judges bench held that if landowner is not willing, state can deposit the amount in treasury but in 2014 three judges bench held that state will deposit such amount in court treasury and not in government treasury. Full stop. So now this matter is to be referred to a five judges bench as per incurium cannot be done away with by same numbered judges bench same numbered judges bench. 2014 में क्या था? That this case was in Pune. 2018 में this case was of Indore. The three judges bench deciding the same thing but for different treasury. Now whom to go for? Now it will be decided by the higher number of judges bench. That's how the per incuria concept is. Understood? Now the next issue is of fast track court. क्या हुआ? So this was also a matter in October 2022 that Chhattisgarh appointed FTCs that I told in the beginning of the class, okay, to dispose of the case for the inmates, jail inmates. But it is a kind of decade-old issue, fast track court. And then after this we will be discussing what is called as Lok Adalat. कल ही डिस्कस करेंगे, फिर क्या करें, ठीक है। It has been amended. So, so earlier, if I am a party and I am having a case in High Court, it has been decided wrongly by single judge bench, and I need to appeal it in the High Court. It could be done, and it could be heard by the higher number of judges benches, but it cannot be done now. So what will happen, that I need to go to Delhi, hiring a new lawyer, giving more money. So hmm, means the two judges bench or three judges bench, or maybe the higher number of judges bench can be there to interpret some of the provision that may be that may be held at the level of High Court also, but not deciding the case again, right? So that's how it is. Hmm. Why? In media, yeah, that was the convention. It has been broken in 2016, right? So they are speaking sometimes, because when you talk about the appointment, then of course it is a neutral issue. It is not influencing the common man, not any judge in particular. But yes, the government is not doing it. But yes, it may be taken as part of judicial activism, that it is the work of an executive, and the government is not doing so, sitting on the file of the appointments. So that is there. So yeah, it may be as part of yeah, e-courts can be there, and these were held actually. But regional benches will be fine, good to go, because there is a concept of ad hoc judges. Who are ad hoc judges? Temporary judges. Ad hoc means temporary. So the retired Supreme Court judge can be appointed as ad hoc judge or not? करते हैं, no, 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 regional bench employment. तो यार experience, regional benches of Supreme Court are to be meant. I have been retired as a Supreme Court judge. My native place is West Bengal. It is easier for me to look after the cases related to West Bengal. All people will be coming Ami Valoshi, so I will be understanding this language very much. So the case in Tamil Nadu. So the regional touch is also there, which is a kind of facilitatory uh, effect in nature, which is otherwise a deniable fact in Delhi, along with the other issues like in Delhi, winter and summer. Okay, so Meghalaya and Tripura. बिल्कुल आता है. There were four northeast state at the time when constitution was enacted, and the disintegration of the northeast into the seven state is the today scenario. So AMTM can be taken up as the Manipur also, the area, right? So all seven states. So in many of the books you will find not AMTM but Northeast. But to be precise, it is AMTM. You are from which state? Manipur. So your state is protected under Schedule 6 or 5? 5. So the regional benches are not there in it. Regional councils are not there in it. These are there. Yeah, these are there. The village councils are also there. So it is Schedule 6 also. Not in books, but it is there. Why it is so? Because when you look at 1951, when the constitution was brought, only 4 northeast states were there, and disintegration of the states has brought it to number 7. Okay, that's how it is. But there is kind of division in Assam also. There are many divisions in Assam which are under Schedule 5, being in Assam, because of a different community which is of different language, maybe Naga. Right? When you will be allotted Assam Meghalaya cadre, there are only 2 states in one cadre, and you will be trying for Assam. In Assam, you will be allotted with one division. So it may be under Schedule 5 or it may be under Schedule 6. So it is for the books only. It is a simplified picture, but when you look at the field picture, it is quite different. Quite different. हाई कोर्ट का jurisdiction कौन अलॉट करता है? High court jurisdiction is a political concept. High court is to be there for a state political unit. One high court may work as high court of adjacent state too. There was only one high court for entire Northeast, Guwahati High Court. But now we have 3 more high courts apart from Guwahati High Courts in Northeast. So for all 7 states, 4 high courts are working as of now. So for example, Punjab and Haryana High Court. Yes or no? 7th Constitutional Amendment Act 1956 allowed it to happen. Along with the governor can be a governor of adjacent state or union territory. Okay. Chalo, tata bye bye. See you.